All right, good morning, everyone. My name is Jess Langer. I use she, they pronouns. For a physical description this morning, I'm wearing green frames. I'm a white woman with short brown hair wearing a pink jacket and a striped shirt. You might see my little white dog pop up on the bottom of my screen today. I'm also joined today by my colleague Brenda Schaefer-Pellinen, and we are both with the Arrowhead Area Agency on Aging, and Brenda will be managing our technology and our chat today. We'd like to welcome you and thank you for joining us for today's session on advanced planning, healthcare directives, and powers of attorney. Before we start, we just want to share a few housekeeping items. Next slide, please. Today's webinar will be accessible to a wider audience as we have arranged for American Sign Language ASL interpreters who will present throughout the session. These interpreters will rotate every 15 minutes, ensuring that everyone can follow the content effectively. To access the interpretation feature, simply click on the interpretation button at the bottom of your screen. Additionally, we are recording the entire webinar with ASL interpretation, and the recordings will be available on our YouTube channel and on the Get Your Ducks in a Row, our website for later viewing. Whether you attend the live session or catch up later, you'll have the opportunity to engage with this material in a way that suits your needs. I encourage you to subscribe to our YouTube channel so you can keep up with the latest additions to our video library. We are always looking for suggestions for future webinar topics. So if you have suggestions for topics and/or speakers, feel free to send those to Brenda at her email, which she will share in the chat now. Please keep your microphone set to mute today. Just a note, if you experience any issues with your bandwidth or audio quality, it often helps to turn off your camera. And if you'd like, you can enter your first name and organization or community that you're from in the chat box. And also what you're hoping to get out of today's session or how you found out about it. If you have any questions during today's session, please feel free to enter your question into the chat and we will coordinate follow-up responses or get to them at the end of our time today. At the close of today's session, you will see a quick evaluation of today's session pop up in your browser. Please take a moment and complete that survey. It really helps us greatly when planning future sessions. Next slide, please. About the Arrowhead Area Agency on Aging, the Arrowhead Regional Development Commission is designated by the Minnesota Board on Aging as the Area Agency on Aging for the Planning and Service Area under the authority of Title III of the Older Americans Act. The Arrowhead Area Agency on Aging, sometimes known shorthand as the Quad A, is committed to helping older adults maintain their highest level of independence. Area Agencies on Aging, or AAAs, are regional organizations that provide the services, supports, and information for just about everything that older adults and their families could need. Minnesota has 7 AAAs across the state that are the local connections to older Minnesotans and the community support they need as they age. The Arrowhead Area Agency on Aging's planning and service area includes the counties of Aiken, Carlton, Cook, Itasca, Koochiching, Lake, and St. Louis. Next slide, please. Now I'm going to take a moment to read our Arrowhead Area Agency on Aging land acknowledgement. As we support our mission to help older adults maintain their highest level of independence, we do this while being respectful of the space we are being welcomed into by Indigenous people. We strive to deepen our understanding of the multiple ways in which people see and understand land and acknowledge the Indigenous people who have relationships with this land. We also acknowledge the decades of historical trauma, loss, and grief experienced by Indigenous people. It is our promise to not only recognize these truths, but also take action to show support of our Indigenous elders, neighbors, and friends, and understand our place within the past, present, and future of this land. We know this is just one step in recognizing and honoring the sovereignty of tribal nations. Now, it is my pleasure to introduce our presenter today, Kristin Parendo. Kristin is the lead elder law attorney at Justice North, formerly known as Legal Aid Services of Northeastern Minnesota, which provides free civil legal assistance to people across our region. Kristin specializes in elder law and brings extensive experience helping older adults and their families navigate healthcare directives, powers of attorney, and other essential planning documents. She is also a key partner in the Get Your Ducks in a Row campaign and leads in-person community workshops throughout northeastern Minnesota where participants can complete their planning documents with expert hands-on guidance. Kristin, thank you so much for joining us today. The floor is yours.
Thank you very much. Well, you see our slide today, we're going to talk about healthcare directives and powers of attorney as the main tools of advanced planning that everyone should have. So let's start off. Let's go to the next slide, please. So before we get into the meat of the meeting today, I want to just say who we are for those who don't know about Justice North. We are a nonprofit civil law firm, and we cover now, since our merger this year, we cover pretty much the top half of Minnesota. So 33 counties, and we have 8 offices. So we merged with Legal Services of Northwest Minnesota. So now we're all one organization called Justice North, which will be good because we can help more people. We have 2 Title III regions in our service area. And our service area is 52,000 square miles. So that's a lot of area. So our mission on the screen, you can see there, we're here to help people that need help getting an attorney and getting their legal questions taken care of. We're free, but we do accept voluntary donations. And the key point that I want everybody to know is that if you're 60 or know somebody who is 60 or older and they have a legal question or they might have a legal problem, please have them call us because we don't have the same income and asset guidelines as our other funding grants do. So we can help them. And if there's something we can't do, we will get them to the right place. So we do all civil law. We don't do any criminal law. And the elder law team focuses on long-term care, keeping people in their housing that they choose to be in, helping with benefits, income, basically anything in the civil realm. So let's go to the next slide. All righty. So here's today's agenda. We're going to talk about why should you do this, who would make a good choice for your people, for your documents, and what are those documents and how to fill them out. Now, I know we have a wide range of people on this webinar, so some of it might be something you've seen or heard already, but I'll try to sprinkle in other things as well. Please ask questions as we go. And I'd be happy to answer them. If you're here from an organization and you'd want to have help anytime with a situation, we can talk hypothetically without having to have a client. And then if you want to send somebody our way, I'd be happy to have them as a client too. But this topic covers everybody. So everybody in Minnesota should think about and have these documents if they can. So let's go to the next slide. So the 3 documents we'll talk about today are healthcare directives, the provider order for life-sustaining treatment, that PULSE document, so the EMTs will do what you want, and the power of attorney. We're going to focus most on the healthcare directive and the power of attorney because not everybody needs the provider order for life-sustaining treatment, but it's good to know about. So let's go to the next slide. So what is advanced planning? So you do it so you can have your life controlled by you as much as possible. So your wishes and goals are met to the highest extent possible. And you do that by putting it in writing, because when you become incapacitated or incompetent, you perhaps can't communicate your wishes and goals. So if you put it in writing while you can in certain legal documents, those legal documents have the best chance of your wishes and goals being followed. If you don't have it in writing, then you're putting it all to chance. And some things aren't going to happen. So you want to be able to have somebody to step into your shoes to do those things. So you keep control by having somebody do things for you when you can't do it. And I've got lots of examples I can go into, but I'm when that doesn't work, when you don't have the documents. But you know, you've all seen that before in your own lives too. If, if nothing is in place, usually the status quo is just kept in place, and no, the healthcare providers won't necessarily do anything. Certainly, they won't do it if there's a dispute amongst family members. Same thing with financial matters. If you don't have somebody set up for your financial matters and you become incapacitated and there's nobody that can access your money to pay your bills, then they're going to have to file for conservatorship. And that means you don't have any control anymore. So let's go to the next slide. And just talked about some of these things. It's all about control. You want to control your life, this is the way to do it. And you do it by sharing your authority with somebody to step into your shoes. You're not giving up your authority. A lot of times, adult children might overstep their bounds sometimes once they become a power of attorney, for example, and they may think, well, I don't like what mom's doing with her money, so I'm not going to do it. That's the incorrect way to act as somebody's power of attorney. So when somebody acts for you in any of these documents, they have a fiduciary duty to do what you want. And if they don't know what you want, they have to act as the best from the knowledge of you and conversations that they've had with you. They have to act as close to what they think you would have wanted. With a power of attorney, for example, they have to act as a reasonably prudent person would in the same situation if they absolutely don't know what you would do. And both these documents are good because you keep your private matters private. You don't have any court oversight like you would have in a guardianship or a conservatorship. If you don't have a healthcare directive, that's when the guardianship might be needed. That's when somebody's going to say where you live, and the court is going to look at all of your what's going on in your life. They're going to oversee that. Same thing with conservatorship with your money. But beyond that, these documents make it so much easier for your family members to do what you want because they have something to guide them. And best practices, if you have a conversation about it ahead of time, they'll know even more what you want. So then they can act with confidence and they can act without any guilt when they don't know exactly what you want. So it's really a gift to your family members to have your documents in place. And it's a gift to yourself to make sure that your goals and wishes are followed to the best that you can. Let's go to the next slide. So who should do this? Anybody 18 or older, because everybody has their own body and what they want in their life, and they have their own personal belongings and some money and their personal information. So these documents can benefit anybody that falls into that category. So it's not just for older adults, it's for all of us who are 18 or older. So let's go to the next slide. And I should say it's 18 or older because when you turn 18, your considered an adult and you have the ability to contract. So that's why you have to wait to 18 to do it. Alrighty. Also, it's especially important if you fall into any of these categories to think about and get these documents. For example, if you're unmarried, you don't have that automatic spouse. You know, for example, if you go to the hospital, the providers are going to look to the spouse for information and what to do. If you're unmarried, they're not necessarily going to do that with the children. With children, there's more likely to be fights. If you have a significant other, oftentimes the significant other is not going to be listened to at all by anybody about your matters. So you should have these documents in place. Similarly, if you don't have close family or you don't want those family members to make those decisions for you, you want to put somebody else in place. Second marriages can be a problem, especially if there's adult children who don't like your significant other. That's when problems happen, when you're not able to communicate and make decisions. They sometimes sweep in and fight your partner. So you want to make sure your partner is your named person. And finally, if you get a diagnosis, then this is certainly a good thing to do because each diagnosis has its own timeline of potential loss of control. So you want to get documents in place as much as possible. And you can also do some long-term care planning, protect some assets, but that's another topic. So let's go to the next slide. Who would make a good candidate for any of these documents? Well, who cares about you? Who comes to visit you when you need help if you're in the hospital? That's probably likely people. You want to see if they're trustworthy. Sometimes people name children on their bank account as a convenience. And if they haven't stolen your money, that's a good indication that they're trustworthy. But you know your people. Look at them, look at their situations. Do they have any temptations in their life? Are they going through money troubles? Things like that. Most importantly, are they willing to act? And if they're willing to act, will they do what you want? Because if they don't do what you want, but they're willing to act, you don't want them on there. You want to gauge their willingness and their acceptable, if they accept your instructions. Another thing to consider is what are their strong suits? Some people are good with paperwork and money. Some people are good with dealing with healthcare matters and doctors. So put them where they fit the best. You can have the same people on all the documents. You don't have to have all the same people. It's all up to you because it's your document. And I get this question a lot. Do they have to live near you? They do not. We're connected by technology very well nowadays. So you can have somebody who lives in a different state across the country. Ideally, if you have somebody nearby, that makes it very easy for people to act, but they don't have to live near you. All right, let's go to the next slide. So how do you actually do the advanced planning? Two things, legal documents, communication. They're both equally important. Communication, if they don't know what legal document is or what your wishes are, it makes it hard even if they're named on the document. So best practices to have a conversation with them before. Are you willing to act? If so, this is my viewpoint and what my wishes and goals are. And then when you have the document done, you share it and you talk about it. Let's go to the next slide. Whoops. There we go. And you don't need an attorney to do any of these documents. There are attorneys that will do them for you. We will draft power of attorneys for folks. If somebody has a healthcare directive and a has questions about them, we can help with that. But we don't do healthcare directives for folks on a regular basis because you really don't need an attorney. But certainly power of attorney is something that we will draft for folks. Let's go to the next slide. So when do you use these documents? They're all before you die. So, for example, the healthcare directive is used when you cannot communicate your wishes or understand your healthcare options and your doctor says you can't. So then they look to the document, and if you have an agent on there, they'll talk to your agent. You'll see in the next slide, the healthcare directive also comes into play after you pass away. If you put information about what to do about your body and organ donation, it becomes a funeral directive in that case. Provider order for life-sustaining treatment is used when you are maybe have a serious life condition and are maybe at 2 or less years of life left. This is so that ambulance people will do what you want in that emergency situation. And of course, power of attorney is used during your lifetime. It's automatically terminated at death. And you'll see that on the next slide. We just talked about that, so we can go on to the next slide. Alrighty, let's take a look at these documents. So we're going to do healthcare directive first. And I know probably all of you have seen a healthcare directive before, but I want to go through it, the short form. But there's lots of different forms out there. And if you don't like one, we can find you one that you do like. But they all have 4 main parts. You have to identify yourself. Number 2 and 3 are optional. You should do one. If you can, do both. So you can pick people to act for you, and you can have instructions for them and your providers. If you don't have somebody, you can still have a healthcare directive because you can just have instructions. This is very important for our older adults who are solo agers because everybody has wishes and goals, and their provider will follow them if they're written down. And then it's signed either in front of a notary or 2 witnesses. 2 witnesses the witnesses cannot be your healthcare agents. We've had a couple of cases like that come through where somebody has done a healthcare directive and then they became incapacitated, and their significant other was the client came in because the healthcare directive was not being looked at. And that's because it was invalid because the healthcare agent were the witnesses who signed it. So the safe way to do it, if you are worried about it at all, is to sign in front of a notary. And the website on the bottom of the slide is our do-it-yourself healthcare directive, which is pretty nifty. If you haven't gone to lawhelpmin.org and do the do-it-yourself healthcare directive, there's one for power of attorney too. It will walk you through and ask you questions about different healthcare scenarios and things. And at the end, it'll print out a completed healthcare directive for you. So all you have to do is take it to your notary and sign it. So that's kind of a nice way to do it too. All right, let's go to the next slide. So this one that we see here is the short form from Honoring Choices, and it's just a front and back page, but it has all the required elements in it. So you identify yourself on the top. None of the healthcare directives now ask you for your social security number. Certainly don't put any social security number on any of these documents. And then you can see I appoint the following person to serve as my primary healthcare agent. So This is where you have the option on this form to have two people, a primary and one alternate. So you might not want that. So you can have another form so you can have them have it arranged a different way. Sometimes people want co-agents, although if you have co-agents, you got to have a way to break a tie. So that can be kind of tricky. But you might want to have more than one alternate, so other forms have more space. So check out other forms if you don't like the short form. The second question on here says optional. That's where you give your instructions. So it's always good, in my opinion, to do instructions because your agent might not know what you want just because they're named on there. And your healthcare providers, when they read your healthcare directive, they can get some more ideas rather than just speaking with the agent. On this form, there's not a lot of space. So you should just maybe do your philosophy of end of life, what's important to you, type of statement there. But if you do need more space, you can see on this document and on all of the healthcare directives, you can add pages to add more. And then you sign it in front of a notary or two witnesses, just like I said. And you can see on the bottom, it says witnesses must be 18 or older and cannot be your agent. So let's go to the next slide. So what do you do with it afterwards? You want to keep it with your important papers at home. You want to make copies for all of your agents, make a copy for your doctor. You can file it at your local hospital and they'll scan it and keep it in their electronic records. Important thing to know about healthcare directives, a photocopy is just as valid as an original. So it doesn't have to be a wet signature. They don't have to see an original. A copy is just as good. And to revoke a healthcare directive, you make a new one because that automatically revokes all prior healthcare directives. So you want to make sure you remember who you gave your healthcare directive to. So I would put a list next to it so you could give a new one to everybody who you gave your old one to in case you change it. You can revoke it by ripping it up, telling people that it's revoked. If you have that list, it's best to tell everybody that it's revoked. But it's cleanest and clearest if you make a new one. Let's see. What else for healthcare directives? I think that's it. Let's go on to the next. So we're about halfway through, so I'm going to go right through the polls pretty fast because I want to get to power of attorney. So the post is the provider orders for life-sustaining treatment. This is a traveling doctor order, so the EMTs will do what you want in that emergency situation. Because without it, they're going to stabilize you and get you to the hospital. And stabilization can mean CPR. It can mean all sorts of, it may be intrusive treatment like tubes that maybe you don't want. So if you don't want that, if somebody calls 911, you should have a post. And it has 6 main parts. You identify yourself. You have some preferences you can check off on the form. And it can be, I want CPR, I don't want CPR, I want this, I want that. Let's look at it coming up. There's a place that you can document who you discussed it with. The doctor signs it and dates it. It could be an advanced practice nurse or a physician's assistant as well. They have some optional treatment preferences you can put your opinion about on there. And then the place name for the person who fills out. And you can get that form at that website. If you do the post, you want to talk to your local EMTs and see where they like to look for it when they come to a call. Oftentimes it's on front of the refrigerator. And usually the people who would like to have this form are those with a serious healthcare decision or a life expectancy of less than 2 years from their prognosis. So let's go to the next slide. And that's, if you hear the scratching, that's my cat on the door. I hope it's not annoying people too much. So here's the form. Provider orders for life-sustaining treatment. And you can see there's an identification portion. You don't put your social security number on there. And then you talk to your doctor about it, and the doctor checks it off the way you want it, or you could pre-fill it in. The doctor has to review it because it's the doctor's signature on the form. And you can see there's medical treatment on there. The first one, of course, though, is CPR. You want them to attempt it or don't attempt it. And then there's the section B talks about, do you want full treatment, selective treatment, or comfort focused treatment? So if you want full treatment, you probably are going to say attempt CPR on the top and then full treatment and go from there. But you can see it's meant for anybody, for all wishes. And let's go to the next slide. And this is the second page, the last page of the form. And you can see you put your name on the top there. So when it gets scanned, if it gets scanned anywhere, a loose page will have your name on it. And then it has some options for more preferences, like feeding tubes, antibiotics, those sorts of things, and a spot for your other preferences. And that's all there is to a post. It's a traveling doctor's order. Pretty handy. All right, let's go to the next slide. All right, powers of attorney. So this also, this has 7 main parts. So always, you can see, identify yourself. You get to pick your people. Here they're called attorneys in fact. You're sharing your powers. You're not giving up any power. Nobody can tell you what to do. They can't do what they want with your stuff or information. So you have to decide what powers to share, decide if you're going to allow transfers to them or somebody they have a duty to support. You decide what kind of accountings they have to provide to you, and then you sign it in front of a notary. Your people do not sign in front of a notary. They just sign on the back, two spots, and you'll see it. So let's go to the next slide. So this is the form that you can get at the Minnesota Department of Commerce's Uniform Conveyancing Blank forms. And this is the one that I use. But any of the forms that are called statutory short form power of attorney, they all have the same stuff in it. They might use different fonts and things like that, but they all look the same. If it's modified at all, or a section is taken out, or something is added, that modifies it into a common law power of attorney, which doesn't necessarily make it invalid, but you take it outside of the whole chapter of statutes that go along with this. So chapter 523 of the Minnesota statute has protections and enforcement features. So it's good to stay in that chapter, because once you present it to somebody, or your person presents it to somebody like a bank, if it's valid on its face and they don't honor it, that chapter has statutes that your person can use to enforce it. Common law is not quite so clear, and there's more wiggle room. So everybody should have a statutory short form power of attorney. If you have a lot of money and have more instructions that don't fit onto this form, you should have a common law as well. And that you would go to an attorney to do. So this form from the Department of Commerce, you can see has a blank spot on the top. That is there, when it's printed out, it's blank. It's there to give the county recorder's office a spot to put their stamps and things if it's used for real estate filing. And we'll see later, real estate filing is important because if you don't put who filled out this form on your document, it can't be filed at the county recorder's office. So it's important that that's filled out as well. All right, so you can see that it's referencing the chapter there. It's chapter 523. If you go to statute 523.23, you can see the form itself. It's really a really good form because everybody recognizes it and will honor it because everybody knows it now. So who are you? If it's your document, you're the principal. You put your full name and address. And then you put down your people. And there's different ways to arrange people on this document. On the left-hand side where it says attorneys in fact, that's your primary person or people. So they are on deck. They can act immediately upon your signature. So this document is different than a healthcare directive because there's no trigger for this document. It can be used right away. For our purposes, most people don't, it's not used until somebody becomes incapacitated or incompetent. That's what makes it durable. You check out the box that says that. But if you don't check that off and you check off, it doesn't continue to be effective. You'll see that it'll stop. You can't use the form if you don't check that off, if you become incapacitated. So you can see that everybody who uses this form, it's automatically usable right away. Healthcare directives are triggered by the doctor saying you can't understand your healthcare options or treatment anymore, and you can't communicate. Alrighty, so attorneys in fact, if you have more than one, you just put them one, and then the second one, third one. There's not a whole lot of space. But you can have more than two people if you want. They can be squeezed in. And if it doesn't work on this form, there's other statutory forms that don't have the lines and you can squish people in more. But this works pretty well. If you have more than one primary, you have to decide, do you trust them enough so they can act independently? Or do you want them to act together in all things and all decisions? There's no wrong answer for your document. It's just there's pros and cons of doing it both ways. So if you don't trust your people, it's a good safeguard to make them do everything together. So if they sign a check, for example, they would have to each sign the check, and they would sign it as, if it was my power of attorney, they would sign my name as attorney in fact. My name would be Kristin Parendo by my person's name as attorney in fact. So it's clear that they're acting for me, but both people would have to sign that if they were acting jointly in order for it to be effective signature. And sometimes that can be a pain for people to do if you trust your people and if they're not living close by one another. It's maybe better to do independently. So then either or can sign things and make decisions. And then on the right-hand side, there's a spot for alternative successor attorneys in fact. So the people on the left-hand side, your primary people, if they can't act for whatever reason, let's say they become incapacitated or they pass away, or they just decide they don't want to do it, then your successor attorneys in fact can step in. So there's a spot for a first successor and a second successor. For my clients with a lot of children, this is really nice because they can put everybody on the form and not feel bad about leaving anybody out if they wouldn't necessarily want one child as a primary, for example. And on the bottom, we don't put an expiration date for planning purposes because you want it to continue until you either revoke it or you pass away. So to be clear on the form, I write the word none on the blank for expiration date. So let's go to the next slide. So here we can see there's the next two decisions. So this first section is all about the powers that you can share. You can see it lists all sorts of different scenarios. So somebody might choose that they want somebody to act for them in one discrete act, and they would check off the, the power that it matches. For example, if somebody wanted to just do something with transferring a real estate property, they would check off A, and then they would fill out the rest, that county where the real estate is and the legal description of the property, and then go on, because their person is only allowed to do that property transaction. But that doesn't fit our purposes for planning. You want to be able to have your person step in and do anything with your personal property and money and information purposes. So that most likely fits N, where it says all the powers listed, A through M, where you can even see that they're in all other matters other than healthcare decisions under healthcare directive. So they put in that last bit about healthcare directives just to make it clear that the power of attorney does not cover any healthcare. And here's a tip. Healthcare directives allow people to get healthcare information. The statutes 523 for power of attorney do not allow people to use a power of attorney to get healthcare information. So if you want somebody to have access to healthcare, you should have a healthcare directive or a healthcare power of attorney, or both. So everybody should check in probably for their power of attorney for planning purposes. Certainly if you trust your people. And then the second section there on the very bottom, that's where you would check off that this document continues to be effective if you're becoming incapacitated or incompetent. And that's what makes it durable, and that's what you want. So I would recommend checking that first line off. So let's go to the next slide. So there's only two more decisions left. So this next decision in the third section is that transfer of permission that I talked about earlier. So if you say yes, transfers are okay, this gives your person the ability to transfer up to the annual gift tax amount each year to themselves or to their children or somebody they have a duty to support. And I think it's $19,000 per year. So for example, if I check off, yes, I authorize my person to make gifts to themselves or somebody they have a legal obligation to support, they can take my money and put it into their name or give it to their children. If you trust your people, that's perfectly fine. Oftentimes people have a pattern of gift giving and they want to continue to do that even if they're incapacitated. So checking off that second line where it's authorizing transfers makes that easy to do for grandkids, for example. So if you don't authorize that, then your person can't do those gifts any longer. Keep in mind, even if you check this line, they have a fiduciary duty to you. So it has to be according to your wishes and instructions. And if they don't know, they shouldn't do it. They have to act as a reasonably prudent person would in that situation. It's perfectly good also, though, to say, no, I don't want any transfers to them. And that can be okay. There's no wrong answers. It's whatever your situation is and what you're comfortable with. If you totally trust your person, it kind of makes sense to authorize transfers because it goes along with sharing all the powers. There's a kind of a symmetry there. They can do anything for you that's authorized under the statute. But for example, if if you wanted them to do $20,000 to somebody, this document wouldn't give them the authority because there is that limit in the 523 chapter. So that's where if you were really rich, you'd probably want a common law power of attorney to go along with it. So hopefully that's clear. This is just a safeguard section where the legislature wants you to think about it. Do you want them to be able to get money into their hands? Yes or no? Fourth, the last decision. What kind of paperwork accounting do you want your people to provide you? You have a right to know what they do, and you have a right to get that in writing, and that's called an accounting. So the two choices are, I get one when I ask for it, or if it's otherwise required by law. That's the first one. Second one, or I get it whenever a certain time goes by. So each month, each quarter, each year, they have to provide me one. There's no wrong answer. I always suggest that the attorneys, in fact, keep a notebook. So each time that they act for the principal, should make a note of the date, what they did, the reason why they did it, and then have a way to store receipts and paperwork that goes along with whatever the transaction was. So a notebook and a binder would be good, because when the principal asks for that accounting, or you have to provide it on a regular basis, you already have it in writing. You just have to make a copy of it and provide it. So that's the best way to do it. So you don't have to go back through your records and see, well, I wrote a check on state. You would have a note of that, and you could easily get a copy of the check. Or each month you can put a copy of the checks in the binder. So that's the way to do it. Pros and cons. If you trust your people, they might get annoyed by having to do an accounting on too short of a basis. If you trust them, maybe it's not necessary to have them do it on a regular basis, just when they ask for it. Either way is okay. Another note, if somebody thinks that somebody's taking advantage of you, they can do a vulnerable adult report, but there's also other things that can be done, such as financial protective order can be filed with the court. So the court would then ask for it, accounting, and say what's going on. And you can ask for a protective order too if you're able to do so. So that's the last decision of a power of attorney. So there's only 5. It's not too hard, but it's a very powerful document, and I like to talk with folks about who they choose and various things like that. So I can draft them for people if they want to come to us. And then as the principal, you sign in front of a notary. So you can see your signature line there in the middle, and then the notary fills out all the rest on the bottom. The most important thing for people is to not get excited and sign it until you're actually in front of a notary. Let's go to the next slide. So then we're almost at the end. This is page 4 or 5 of a power of attorney. And you can see on the left-hand side there, it says this instrument was drafted by. You're supposed to put the name and address of the person who filled it out. And if I was drafting it, that's where my name and information would be. This is known as the draftsperson's blank or block. So if that's filled out, it's usable to do real estate transactions and file them with the county recorder's office. It's also good for me, if somebody comes to me as my client's power of attorney, I like to look at this to see who filled it out, as just one bit of data in my county power of attorney, and the principal's interests are aligned. Sometimes things are forged, but not often. But I like to check things out. If the client filled it out or somebody different, obviously that's not probably a forgery from the power of attorney child in front of me. And it's not I'm not saying that an adult child who helps fill this out is doing anything wrong by any means whatsoever, but it's good to have people who fill it out there. Um, so then we can ask more questions if needed. So on the top, page 4, it says acknowledgement and notice to attorneys in fact and specimen signature. So there's 2 signatures. One for this little blurb saying that your people have read the important notice to the attorney in fact, which is on page 5. That says basically what is a power of attorney, what their duties are, things like that. So they know what they're getting into. If they agree to it, then they sign that they read it. No notarization. The second lines, section of lines underneath that is the specimen signature. That's just for an example of their signature. That's a holdover from the prior version of the form when that acknowledgement part wasn't on it. They just kept both spots for a signature instead of just combining them. So it's kind of funny that they have to sign 2 spots, but they sign 2 spots. That's just the way the form is. And the specimen signature is a way for a person who is reading the power of attorney to compare the signature of the attorney in fact on the form with some identification signature, like a driver's license, just to see if that person is who they are. And then on the bottom of that is a section where the principal, you would read it and learn more about the power of attorney and everything that we talked about, really, including about revoking power of attorney. That's on the next page. We can go to the next page. Alrighty. So you can see on the top, it talks about termination. So for example, if you've made a power of attorney and you don't like it anymore, or your person is no longer available, or heaven forbid, your person has violated their duties by stealing from you, you want to terminate it right away. It's also called revocation. The way you revoke it is by signing a revocation in front of a notary and then giving that revocation to your attorney in fact. Until they get that notification, it hasn't been completed. So you have to give that revocation to your agent. Best practices, you want to give that revocation to anybody else who has seen your power of attorney so they know not to do business with that person anymore. A revocation form is good when it says you've have a power of attorney dated such and such date, granting powers to this person as attorney in fact. I hereby revoke that power of attorney and you sign it. Very simple document. If you go online to the minnesotalawhelp.org, there's a fact sheet. And on the fact sheet, there's both the form and the revocation form. So you can get one there easily. But there's no like magic form. It's just, I revoke this power of attorney. This is the information about the power of attorney, and you sign it in front of a notary. So it's not like this form where it has to have certain things in a certain way. Alrighty. So there you can see the attorney in fact notice that they read. And then they sign. So let's go to the next slide. And what you do with it, you can do a few different things. You could keep the original just in case it's needed for real estate and you know where it is. Keep it with your at home, not in a safety deposit box. Or you can make originals for everybody, which means type it up and then sign each one as an original. And you can tell it's an original because of the wet signature. But you don't have to do it that way. Copies are not as good as an original just for the county recorder's office. Everybody else should be fine with the copy. So don't give your original to the bank or the insurance company or anybody like that. Just keep it in case you need it for the county recorder's office for whatever reason, because you never know if you have real estate now or in the future that needs to be recorded. Attorneys, in fact, should have copies or the original, depends on what you like to do, and give a copy to your bank or other entities you do business with ahead of time. So then if they've got a problem with it, you can come to us and we can educate them that it is a valid document that they do have to follow in Minnesota. It's not so much a problem anymore, but some national banks in the past have had some problems with it, but they've all been educated. All righty, let's go to the next slide. And then I have links to the documents in these next few slides. So, and also there's websites where you can go to get them. So feel free to do that. Put a plug in that do-it-yourself documents at the minnesotalawhelp.org. It's nice ways to walk you through the different decisions to make on the healthcare directive and the power of attorney. Let's go to the next slide. And then there's where you can get the statutory short form power of attorney and fact sheets. This the lawhelpmill.org do it yourself. There's another, you go to that website and you can find it for the do it yourself. The nice thing about it is it doesn't save it after you completed it. And if it's saving it temporarily while you step away, nobody has access to it on their end. So you don't have to do it all in one sitting, and it's still safe information. Alrighty, let's go to the next slide. And here we are at the end. Here is my contact information. Feel free to email me or call or text. If you've got hypothetical situations, I'm happy to help out. If you've got somebody that you want to talk about to do the intake, they should contact our main number or go do an online intake application. But certainly we could talk about hypotheticals beforehand, before I have a client even. Let's go to the last slide, and there's some information about Arrowhead Area Agency on Aging. Thank you to Brenda and everybody there to help with this webinar, Get Your Ducks in a Row series of workshops that are coming up. And we're funded by the Minnesota Board of Aging Older Adults Act, which is very important. If you know anybody across the country, that act funds similar legal services organizations in all regions of each state. And if you need somebody to help you find out who that is, contact me and I'll be able to look it up for you. But thank you very much. Is there anybody with any questions? I haven't been looking at the chat. Let's see.
Thank you so much, Kristin.
Mhm.
I haven't seen any other questions come in the chat either, but if you have any questions, please put them in the chat now. We've just got a minute left of our hour today. And if you have any other questions, Chris put her information on the slide. You can also reach out to me. I'll be sending a follow-up email to all of our participants today and those who registered, but weren't able to attend live with slides from today and some resources, and you can let me know if you have any questions and I can pass them on as well. But thank you so much for this practical and informative session. Before we wrap up, I just want to make sure everyone knows about our other Get Your Ducks in a Row webinars coming up this week. They're all free and they will all be at the same time, 10 a.m. to 11 a.m. each day this week. So tomorrow, Tuesday, April 14th, we have Building a Community Legacy, Making a Lasting Impact. Wednesday, April 15th, we have Creating Your Family Legacy, Values, Stories, and Connection. Thursday, April 16th, we have Understanding the Dying Process. And Friday, April 17th, we have A Mindful Path to Peace Through Purposeful Decluttering. Brenda will put the registration links in the chat for those, and you can also find out more information about our in-person workshops that Kristin mentioned earlier, that are coming up throughout our region at ducksinarowmn.org. And Brenda will put that link in the chat as well. And we are just up at our time at 11. So Kristen, on behalf of the Arrowhead Area Agency on Aging and everyone who joined us today, we just want to thank you so much for your time and your expertise. And the work that you and the team at Justice North do makes a real difference for families across northeastern Minnesota. And to our attendees, thank you for being here, whether you're planning for yourself or you're helping someone you care about. We would just want to acknowledge that you've taken an important step today, and we hope this session gave you both the knowledge and the confidence to move forward. Today's recording will be available on our YouTube channel in the coming days, and we'll send a link to all registrants, so watch for that in your inbox. In the meantime, you can always find us at arrowheadaging.org, and we wish you all a wonderful Monday. Thank you.
Thank you very much.
Thanks, Chris.